Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. Video number 1458 maybe. This time we are going to discuss the topic professional ethics, particularly rule number 49 of the professional ethics. Actually, rule number 49 prohibits the advocates from practicing any other profession or employment or any concern. So as long because the profession, legal profession is a 24/7 profession. It's a noble profession, but you should concentrate only on law, nothing more than that. Of course, the distinction takes place from Roman 47, where you cannot be a partner, but you can be a sleeping partner, all these things. We are concerned with rule number 49. Supreme Court, of course, it has not decided the matter. It's posted the matter to 22nd February 2022. The case is filed in 2020. The point is whether an advocate can continue his employment till he passes the All India Bar examination. This is the point in question. So, the case law relating to this is Bar Council of India versus Twinkle Rahul Malgaonkar, BCI versus Rahul Malgaonkar, Twinkle, not Pinky, Twinkle Rahul Malgaonkar, 2020. This is decided by High Court of Gujarat. If you know the facts of the case, it will be better for you to appreciate. Mrs. Twinkle Rahul Malgaonkar. She is a widow. She is working in a private company. Of course, since it's a private company, that too, she goes to the office now and then. She completed law course, and after getting enrollment, now she has to pass the All India Bar examination. Now the point is, the Bar Council of India, for this enrollment, they said that you have to withdraw from your present the so-called job, otherwise you are not given the enrollment. Then she put a question. No doubt, now you are allowed me to practice, but if I fail in the All India Bar examination, are you going to take me? No, absolutely. Your temporary ID card will be taken back. Then that job will not be there for me, because when say retire, when say resign for the job and take 2 years for passing this examination, then it's difficult for me. So why don't you allow me to continue in the job till I pass the All India Bar examination? This is the question she has put, and it is now still under inquiry. Of course, the Honorable Supreme Court of India, of course, Gujarat High Court has given a clear decision that till she completes the All India Bar examination, definitely she can continue her job. Number one, basing on her condition, she is a widow and she is the job, she has to depend on the job only to feed her family members. But against to this, Bar Council of India has approved the Supreme Court of India. Why? Because Rule 49 says an advocate shall not be a full-time employee, salaried employee of any person, business firm, government firm, corporation or concern, so long as he continues to practice, and shall, on taking up any such employment, definitely has to inform the Bar Council of India, on whose role his name should be seized or removed, or he will cease to practice as an advocate. This is very clear in rule number 49. Of course, a lot of judgments are there. Besides this, Ashwini Kumar Upadhyay versus Union of India 2018 has actually blasted a bomb against the so-called MPs. At that time, Chidambaram and others, they were ministers. Anyway, against the Arun Jaitley, all others, I think 2018 they were there or not, I do not remember. But anyway, his contention is that the advocates who are elected as MPs, they are attending the court. They are taking salary as MPs, they are taking salary as ministers, and they are attending the court. Can they do it? Is it Rule 49? Will it not come as an obstacle? So he has filed that case also. In that case also, Supreme Court raised its hands stating that it is a profession, we can't do anything. But anyway, as far as this Twinkle Rahul something she is concerned, so the problem is very typical. It is actually genuine problem. So the court appointed Shri K.G. Vishwanatham as the amicus curiae. Ultimately, he has supported the version of this woman. What he stated is, till she clears the All India Bar Examination, let her continue her job. But for that, the Bar Council of India, they have to change the rules. Are they ready? They are not ready. So Supreme Court asked the Bar Council of India to have a reconsideration, to reconsider the issue. That means to put it before the meeting and let them come to a conclusion whether they will allow, whether they will not allow. All these things they have to discuss. So anyway, very good point for Rule 49. So as professional advocates and in the part of professional ethics, you have to remember. So already I told you, whenever you want to practice, whenever you get for the enrollment, definitely you have to withdraw yourself from the so-called job, whether it is a private job or a government job, whether we are working as a PA to somebody, whether you are working as a company secretary to somebody, definitely you have to withdraw from it, because legal profession is 24/7 profession. You have to concentrate only on law. This is the thumb rule. This is the rule made by the Bar Council of India. Now she wants an exception for this. Of course, her cause is also genuine. Let us wait and see what the Supreme Court decides on this matter. But very good point for discussion, particularly for professional ethics students. To conclude, I want to tell you, సహజంగా మనం ఒక లాయర్ అడ్వకేట్గా ప్రాక్టీస్ చేయాలి అంటే ఎన్రోల్మెంట్ ముందే ఉన్న ఉద్యోగాలన్నీ మానుకోవాలి. ఏ ప్రైవేట్ ఉద్యోగం కానీ లేక గవర్నమెంట్ ఉద్యోగాన్ని మానుకోవాలి. కానీ ఇక్కడ పరిస్థితి ఏంటి, ఈవిడ ఏమైపోయిన ట్వింకిల్ మళ్ళీ మర్చిపోతున్నాను, ఈవిడ ట్వింకిల్ రాహుల్ మల్గాంకర్, ఈవిడ విధవరాలు, ఫ్యామిలీ అంతా ఈమె మీద ఆధారపడి ఉంది, ఏదో ప్రైవేట్ ఉద్యోగం చేసుకుంటా బతుకుతూ ఉంది. ఇప్పుడు ఎన్రోల్మెంట్ అప్పుడు ఆవిడ ఉద్యోగం మానేస్తే, ఆల్ ఇండియా బార్ ఎగ్జామినేషన్లో ఆవిడ ఫెయిల్ అయితే మరి అక్కడ ఉద్యోగము పోతుంది, ఇక్కడ మీరు లాయర్గా ప్రాక్టీస్ చేయాలి. మరి ఏమిటి పరిస్థితి? కాబట్టి ఆవిడ ఏమంటుంది, ఆల్ ఇండియా బార్ ఎగ్జామినేషన్ కంప్లీట్ అయ్యేంత వరకు నన్ను ప్రైవేట్ ఉద్యోగం చేయనివ్వండి. ఇది ఆవిడ కండిషన్. గుజరాత్ హైకోర్టు ఒప్పుకుంది, సుప్రీంకోర్టులో సమ్ ప్రాబ్లమ్ గోయింగ్ ఆన్. ఎనీవే, మ్యాటర్ ఇస్ పోస్టెడ్ టు డిసైషన్. లెట్ us వెయిట్ అండ్ సీ వాట్ విల్ హ్యాపెన్. బట్ జెన్యున్ కేస్, ఇలాంటి కేసులు మనం ఎందుకంటే లా డెవలప్ అవడానికి ఇలాంటివే కాదు. మీ కేసులో వచ్చిందంటే ఇంకో కొత్త పాయింట్ కూడా రావచ్చు. ఓకే, థ్యాంక్ యూ వెరీ మచ్.